Elizabeth Fitzgibbon, and I'm running for Congress in Wisconsin's 6th Congressional District as an independent. I began to realize that behind every systemic issue that we face, every societal issue that we experience, it appears to be the result of some sort of flawed or unconstitutional foundation that then both parties simply campaign on the symptoms that are produced by their bad policies. And so that's why I'm running. I'm running to fix the family law domestic relations matter that affects tens of millions of people. But this is much bigger than that, because that audit process that I apply to domestic relations, I now can see in these 11 other areas which are part of my platform, because I've identified 12 key areas that put society most at risk and where we are most constitutionally misaligned. And my goal is to audit these 12 areas for the purposes of regaining constitutional alignment so that we can alleviate the societal symptoms for real, as opposed to applying partisan patchwork solutions to appease the masses. And that's why I'm very, very determined to approach this from a unifying standpoint as opposed to a divisive one, because we are all victims of the same corruption. And the fact that we are divided as a society and as a culture, it simply proves the efficacy of their malevolence. And we need to rally together, and we need to restore constitutional alignment so that we can actually achieve prosperity and liberty. The interesting thing about the family sovereignty bit is that we really need to go all the way back to marriage licenses, state marriage licenses, because, and this is a conversation that a lot of people aren't quite ready to have, but it really is foundational to the conflict of interest, which makes impartial adjudication impossible in domestic relations matters. So I'm totally pro judge, and I think we need an absolutely Loctite judiciary. It's a linchpin of our society. But the problem is when they can't impartially adjudicate because of their vested interest role, that's where we see harm. So as an example, when you have a husband and wife, or whomever, but a husband and wife marrying, and you have a state marriage license, you now have an undisclosed third party to that contract. And then it really isn't an issue until you try to get divorced, at which point then you have to renegotiate terms to get out of that contract, that marriage license, and you're substituting the marriage license for a divorce contract. And now things get very, very murky when you have children, and that's where Title 4D, Title 4 period, but Title 4D specifically as it relates to child support comes in. Because Title 4D is part of the Social Security Act, and it is a federal fund matching program wherein the state receives federal money for the amount of child support collected by the state courts. And so there's a perverse incentive for the states to have imbalanced custody and placement orders for the purposes of having higher child support payouts, for the purposes of having more federal funding come in. And then again, you can't possibly think that the state is going to impartially adjudicate anything that they're a part of when you are a party to the contract for which you have a vested interest in receiving federal funding for certain outcomes. So that's where you have to have the question, how do we get the state out of this role of licensing marriages so that they can properly adjudicate divorces? Because again, you can't be an adjudicator of a contract that you're a party to. It doesn't work that way. There's a conflict of interest. If people don't want to have the conversation, if they're not ready to have the conversation about not having state marriage licenses, fine, but then you need to get federal funding entirely removed from that contract. And Title 4E is, I don't know as much about 4E, but 4E is for CPS and things like that. So across the board, Title 4 of the Social Security Act, both D and E, but for different reasons, both of those create inherent conflicts in the state adjudicating family matters because of its role in being a contract to a marriage and divorce license and contract. And now the second priority And these are in no particular order. It's not like this is most important, but these are, in no particular order. The second one is the judiciary. We've got, rogue judges. We've got judges legislating from the bench. We have judicial immunity. So there's qualified immunity and there's also absolute immunity for judges. These are obviously of huge concern. So I'm not anti-judge. I'm anti-corruption. And so there needs to be some sort of system in place that allows judges to be responsible for decisions that they're making. Another topic that I find particularly interesting that wreaks havoc in society is our debt-based monetary system. That, in my view, is a significant driver of a lot of the societal dysfunction that we face, because our debt-based monetary system is something that's not taught quite literally anywhere. This is something that's very, very, very secret. People don't understand this, and not because people are unintelligent, it's because this information is withheld from them. And when people talk about paying down the national debt, these are all things that are generally impossibilities if you understand the debt-based monetary system and how money is literally borrowed into existence by digits on a screen. And so you can't pay down that, because if you paid down, if the national debts went away, so too would the money supply. And so there's a really, really, really good overview of this. It's about a 45-minute documentary on YouTube. It's called Money as Debt, and it's probably the most consolidated overview of it that I've ever found. And it's fascinatingly horrifying, but again, without question, it's probably the most significant driver of societal dysfunction in our nation. I want to see if there is a way to restore sound money, because this is not that. And we are simply indebting future generations so that we don't collapse now. And then the fourth priority.
Protect your digital personhood. So this is more Fourth Amendment, right? Issues?
Yep. So the violations, the digital violations of the Fourth Amendment. So we've got, AI concerns, data surveillance. We just live in a surveillance state at this point. Yep. And so that's a huge concern. And then the fifth one,
the endless wars, which a lot of this lines up with our pledge. So that's why you're here, right?
The endless foreign wars that are going on.
And reclaim bodily sovereignty.
Yep. So that's the biometric tracking and things like that. How when it's this rule by emergency kind of ordeal, then they get to just, force vaccines, force masking, force social distancing, force curfews. They get to do all of this stuff simply through declaration of some sort of emergency. Also kind of along those lines is there's really no informed consent anymore. I feel like we really don't know how the degree to what we're poisoning our bodies. So as an example, our air is poisoned, our water is poisoned, our foods are poisoned. And we don't really know just how badly they are, because a lot of this stuff it just doesn't need to be disclosed. And so there really isn't true informed consent at all. The next one is the dismantling the healthcare cartel. And with that particular one, I was listening to Brad Smith, who is the leading Democratic candidate in my race. And people who were there to listen to him speak, they were rightfully lamenting about the cost of healthcare. But the issue is that Brad's response to that, though compassionate, his response to it was simply that he intended to declare healthcare a universal right. Well, philosophically, that doesn't work, right? So rights aren't obligations that you get to impose on other people to fulfill for someone else. So we have a right to speech, but you don't owe me a platform. We have a right to practice religion, but you don't owe me a church. And so we don't get into the business of creating obligations for people under the guise of it being some sort of right. So similarly, we have a right to the pursuit of happiness, but we don't have a right to happiness. And so Brad's response, again, though compassionate, it unfortunately resonates with too many people who don't look at the corruption surrounding the outcome that they're complaining about. And so as an example, The proper response, in my view, is not to declare this a universal right and impose obligations onto other people and further expand the government. What we need to be doing is we need to dismantle the healthcare cartel that is creating the monopolies and oligopolies through this fascist structure that's it's driving up costs because we don't have any competition. And so that's the solution, is to look at the root problems of all of these things, not just apply euphemisms to things just to make it feel more palatable to the masses. Like, we really have to have intelligent, principled, philosophical conversations about politicking nowadays, because it's gone so far the other way that this is just, it's becoming a completely unsustainable model.
Philosophically, to say healthcare is a right, it causes someone else to have the obligation to provide you with it. And you can't say it's a human right, but I think it's the right thing to do. I hear so many libertarians now say we would rather fund some kind of Medicare for all or universal healthcare than bombs.
Kind of associated with like the debt-based monetary system. So when we talk about the unsustainability of the, we've got a retirement crisis, and people are not wanting to acknowledge that. You're not going to hear candidates talking about that, at least if they're part of the duopoly. Although in the news, it's finally come out that they're anticipating, I think it was by like 2032, Social Security is going to be done. Like all of that stuff is not going to be available anymore. So when you've got 200 trillion or so in unfunded liabilities, that's problematic, because all of that is happening is they're creating this intergenerational divide between the dependent boomers who are using it and then the people who are much, much younger who are paying into it and who are never going to be able to use it. So people really, they largely don't understand the retirement crisis that we're facing and its implications, because a lot of people really believe that when they paid into Social Security throughout the years, that it went into almost like a trust fund or a savings account that was, the government was just like safely holding on to their money for their future use, but that's not actually how that operated at all. So the government took our money. We were forced to pay into this. It went into a collective government pool for which they then proceeded to do whatever it was that they wanted to do with it. And lo and behold, the well ran dry. And so now we're at a precipice, and we need to really have the uncomfortable conversations about what this is going to look like for our future selves, because we have an entire generation who is justifiably dependent upon it because they paid in and they were promised this, but what do we do when there's an unsustainable model now? So that's an uncomfortable conversation that we're going to have. I see value and concerns on both sides of the aisle. The problem is that I don't feel like either are approaching the result or the solution in a constitutional manner, or in a way in which we're actually getting to the root cause of anything. So for example, the right, they claim to be fiscally conservative, and as a result, they generally oppose the welfare state. The left, they claim to be very compassionate, and as a result, they prefer to have a welfare state available for those in need. Both sides, I can see both sides. However, the issue is no one's really looking at why is there the perceived need of a welfare state to begin with. And if people really got down into the monetary system corruption and they understood the degree to which that causes a huge economic divide between the haves and the have-nots, what you begin to see is that the welfare state is a result of our unconstitutional money supply or monetary system. And we shouldn't just have a conversation about the welfare state. We need to change the conversation into how do we create a monetary system that doesn't require there to be this. We're not doing that. We're not having the right discussions at this point. We're going into the weeds on matters that shouldn't even be an issue.
It's really going to be tricky, the messaging, I think, on these things that are specifically related to financial issues.
Yeah, and I don't disagree, but I think generally the message seems to resonate that here are major areas that we're feeling pains. Let's figure out why we're feeling these. There's usually if not always, some sort of some unconstitutional foundation causing these symptoms. So let's not apply partisan patchwork fixes. Let's audit the disease. Let's actually have the difficult conversations. Let's suspend disbelief for a minute, and let's see the degree to which one thing, if true, has all of these other implications. And rather than talking about all the little implications, let's talk about the meat and potatoes of the problem.
And this is where you go into the electoral system.
And then also the free speech because of the censorship, and then also the indoctrination of our mind. Yeah, so that's just the high level overview of the 12 priorities that, again, surfaced as a result of my case. And I think those are the main areas that we all need to focus on. And how do we restore constitutional alignment? Because, again, a lot of the divide comes from we feel that there are 10,000 ways to approach this one particular issue, when in reality, if you look at it through the lens of constitutional alignment, it significantly narrows what we're allowed to do. And so there really wouldn't be such divide if we use that as the North Star to say, hey, is this constitutionally aligned or not? If yes, then we can entertain some, various options and ways that we can look at this particular matter. But if it's not constitutionally aligned, then we need to look at it differently. And that's just kind of not the direction that we are going, and we need to go that route, in my view.
Yeah, absolutely. And the immunity, when I was reading over this, about like what certain government agents or government agencies, they're just immune. I had a case against a former landlord. I rented a house without seeing it, and I had a really bad issues. But I went to the real estate commission and complained there, because that was the first, it was managed by agents and they were brief. I got public records requests, and I could see, I'm not maybe quite as tenacious as you, but I did do all of that, and I got those records, and I could see that the landlord and the owner had broken an agreement, and that should have severed. They should have broken with the owner immediately, and they didn't. But so I was like given the runaround. They took 6 months to get me the public records when they're supposed to take 2 weeks. And they're like, you can get a lawyer. Then they spammed my email box with, I said exactly what I needed, the name of who the agents were and all this stuff that had supposedly investigated the property management company. They sent me the wrong documents with somebody else's name. To me, it could have been, if it had just been one thing, I'd say, oh, that was an error. But it was layers and layers and layers. And then sending me all this spam, like just junk email. So I thought, this is purposefully like obstructionist, because I think that the way these things work, the North Carolina Real Estate Commission, this property management company owns or manages and owns half of the area of rentals. These people have dinners together, and they protect each other.
Exactly.
Yeah. And I don't know if that's specifically what's going on in your case, but I would imagine there's some of that. And what do we do? The North Carolina Real Estate Commission, they're paid by our tax dollars, and we have no rights for no recourse.
Yep.
Like in my case, there were multiple clear, blatant violations of state statute. 2 town inspections were failed on record, and then I had a private inspection done, and it was just absolutely atrocious. You would vomit if you saw it. Some of the photos from the insulation in the crawl space and what they found. So just blatant. But so what good are these laws on the books?
Exactly.
If you have no actual rights for enforcing them.
When I was working with one of my attorneys, he had said, I need to learn to present myself differently, because he said, and he even acknowledged, he said, I understand that this is a societal double standard. He said, I, as a man, if I were doing what you were doing, people would look to me as this incredible leader, this incredible leader. And he said, but because you're doing it, you present like a...
Yeah.
And I was like, but I'm not. I'm a tenacious mama bear. They messed with the wrong mother bear. So not only am I a fiery mother bear for my one living child, but I have become an incredible mother bear for this country. And I will not back down. I wanted this particular judge impeached, Judge Caberline, and I met with my state rep, and he, through Wisconsin, the Wisconsin Constitution allows the state assembly to initiate articles of impeachment, and then the state senate is the one that would conduct the hearing, as far as I understand it. And so I had repeatedly met with this particular individual, and he kindly did give me many, many, many meetings. However, I have since more or less been ghosted, and I said, I expect that I get to present my case, even if it doesn't go the route of impeachment. I expect to be able to meet with these people to describe my case and the atrocities associated with it. I said, you are tasked with being able to pursue articles of impeachment. And he said, well, we've never done that. I said, just because you've never done it doesn't mean you shouldn't do it. And I said, and there's a huge, huge societal dilemma that you are creating, a rules for thee and not for me. If you do, because he said, well, you have the right to create a public recall campaign. I said, it is not my obligation to go after a judge who has violated your own laws. That is not my responsibility. That is your responsibility. And I said, if you do not do this, I said, in no uncertain terms, it will send a very dark message to the public to say that we, the state legislature, expect you, the public, to follow our laws.
Yeah.
When it comes to the judiciary, they're too powerful. We're not going to touch it.
I filed a complaint against one judge. She's obviously very biased, right? And I even wrote that in and requested to not have her anymore because of the way she had continuously ruled on two separate occasions. After we won in arbitration, because the case was so, I think, cut and dry with this like violation of the building codes, the state statutes. So we win in arbitration, but we can't win anywhere else. Like just procedural crap. There's this great clip. Do you mind if I play?
No, go ahead.
Evite was believing in the law. When push comes to shove, laws are just pieces of paper, and they can be reinterpreted for political expediency. They are the rules made by the ruling class, more broadly, and if those rules don't suit what it wants to do, it reinterprets them or, hopefully, changes them. Ultimately, if it got into the Supreme Court of the United States and I was still alive in that system, I might have won, depending on what the makeup was of the US Supreme Court. In the meantime, the deterrent effect that it seeks, the retributive actions that it seeks, have had their effect. Lawfare is the use of the law to achieve ends that would normally be achieved in some other form of conflict. We're not talking about simply litigating to protect your rights, but rather picking laws to get your man or to get the organization you want to get, not justice seeking its resolution in law. I'm not sure precisely what can be done about it. There is a anti-SLAPP movement in Europe, which I commend. SLAPP is strategic lawsuits against public participation. There is good legislation in California to deal with SLAPP suits and to reverse liabilities at an early stage and to make abusive lawsuits more expensive to conduct. But I think we should understand a bigger picture, which is that whenever we make a law, we create a tool that self-interested bureaucrats, companies, and the worst elements of the security state will use and will expand the interpretation in order to achieve control over others. And that's why law reforms are constantly needed, because laws are abused and expanded. And so it needs a constant vigilance, but also great care in making laws in the first place, because they will be seized upon and abused.
I really feel like the real power is in holding power's feet to the fire.
That was my entire SCOTUS point, where if someone reads the certiorari, that was exactly what I said, which is, again, with Matt v. Ohio, so what? Like, so what if you declared that state laws need to align with the Constitution. When they deviate from their own state laws, then where
What
is
do you
the
do?
enforcement arm? What
Yeah.
are you going to do about that? Because not only because the contract, by being a resident of, in my case, the state of Wisconsin, the contract is that I'm expected to follow these laws, and I expect you to follow these laws.
Right.
And
Right.
so that was where the Mulker versus New York came in, which is why it's this twofold thing, which is Mappy, Ohio, you need to have constitutionally aligned state laws. Mulker says violations of that violate the contract clause of the U.S. Constitution. And so my point was, now we have a huge jurisdictional gap in domestic relations because those rights are being violated consistently among millions and millions of people across this country. And we have no proper path to state adjudication because of the inherent conflict of interest with the state acting as the adjudicator and the adversary to the exact same contract. And federally, we're essentially boxed out due to Rooker-Feldman and due to the longstanding judicial tradition of the domestic relations exception, which by SCOTUS's own admission is a congressional problem to fix. And no one is talking about this. And that's what I was saying, again, to my state rep. I said, I expect that you at least humor me and allow me to present among more people than just you my case, because if you don't, this is a bad systemic message, because the laws that you create are only there for us, not to protect us. They're there for us to follow.
Right, right.
And if we violate them, you send your guys with guns to apprehend us. But if you violate them,
we have to spend
guys are absolved of wrongdoing.
Right, and we're forced to pro se, become lawyers ourselves, which, again, kudos to you. I couldn't
because who can do this? I mean, it's completely unsustainable unless you have. I mean, and that's why I feel like I've been blessed with this curse, because very few. And I'm not tooting my own horn. It's true. With me, but it was a perfect, unprecedented series of events that led to this outcome. And I'm an odd mix of circumstances that allow me to take this to levels that most other people can't.
Yeah, right.
That make me better, just for reasons that make me different.
Right.
And when I had just taken notes, because when you talked about the judicial biases in your own experience, I took some notes on that too, because I have examples of that myself. So as an example, this judge, there's a state statute which requires judges or judicial officers to recuse themselves under certain circumstances, of which Caberline certainly fell into this. So because he created a contract, again, illegally, no less, but he created a contract and now he's adjudicating the harms of the contract itself. Clearly, there's a conflict of interest. You're not going to be able to impartially adjudicate the fallout of your own, malice, right? And so I had filed on 2 separate occasions 2 different change of venue requests citing these conflicts of interest. That was the first. And custodial harms that were resulting, and that was a result of the proof that he could not impartially adjudicate. And Judge Caberline denied both of them. So the man whose feet are being held to the fire, has the statutory authority to determine whether or not he can effectively and impartially adjudicate. And so now I am trapped in this courtroom where he has no real authority. He manufactured his own authority because of creating an illegal divorce. And then after January 6th of 2023, when I stood my ground about, against the fraud and corruption of what he was doing, then there were incredible custodial biases that had resulted because of my refusal to kowtow to him.
Right.
So here's one.
Yeah.
And here's one concrete example of that. So during the period of withholding where Adam withheld our son from me for 79 days during the summer of 2022, among this legal ambiguity, I had explicitly requested that our son not attend this particular school. And then so during that, he went ahead and did it anyway. So then once I got my son reappointed to me on September 9th of 2022, I filed, rightfully so, a contempt charge against Adam for unilaterally determining our child's schooling. Well, the court commissioner Michael Rust, who replaced the now retired FCC John Birmingham, he adjudicated the first hearing on this matter. And I had requested, a few $1,000s in attorney fees and then to have sole decision-making authority over our son's education because I was well-versed in his education. I had previously homeschooled him. And so I very much knew his strengths and what, he would do best at. So this went before the court commissioner Rust, and he found Adam in contempt for unilaterally determining our son's school. However, I was only awarded $250 in attorney fees, which didn't even pay for my attorney's
5 minutes
courthouse that day. And then Adam enrolled our son for our son's first grade year. Okay, so now we're in the first grade year. And then Court Commissioner Rust said, yes, Adam, you're in contempt. Yes, you ordered only $250, but we're going to order that your son attend the school of your unilateral choosing for his second grade year. So Adam was effectively awarded decision-making authority despite having been found in contempt. So I de novoed it, which meant that it went from the court commissioner to Judge Caberline. And this particular hearing, the de novo of the contempt of school, occurred after the illegal divorce, which was after the bias against me had long been since established. And during that particular hearing, Adam was found in contempt by Judge Caberline. Judge Caberline took away my attorney fees. So now rather than even getting $250, I got nothing. And then Judge Caberline ordered that instead of our son attending the school of Adam's unilateral choosing through second grade, it was now through 8th grade. And then we had, like I said, long story short, regarding counseling, because of the tremendous alienation that had occurred. It was horrible. It was absolutely horrible. And then I had gone to the police about it, but we didn't have a placement schedule. There was nothing that the police could do. We didn't have a placement schedule because Adam refused to co-create a placement schedule. And as a result, there was literally nothing that could be done at all. In fact, I filed two emergency hearing requests with the court, but the first one was denied by FCC Lisa Krieger because she looked at the record and she said, I don't understand what's going on. I think you're divorced, so just kind of go away. And so she was filling in essentially for FCC John Birmingham after he had retired. And so anyway, I won't belabor the counseling point, but this particular thing is an atrocity. So we had been ordered to attend reunification therapy. Adam was ordered to pay all of the reunification therapy because it was unanimously agreed to that he was the sole reason for the need for therapy to begin with. So then my son and I are attending therapy. Adam obviously needed to be involved in therapy too because he was the cause of the need for therapy. So obviously Adam's behavior needed to be addressed with a therapist. Well, this was going on for a long, long time. And eventually things got so dysfunctional that I had filed a sole custody motion. The longtime reunification therapist had been subpoenaed to testify about her experiences because she had seen the same psychological abuse and alienation and manipulation that I had spoken of forever. And that hearing resolved, quote unquote, within less than 20 minutes. Judge Caberline refused to allow the testimony of the court-ordered reunification therapist. And later on, it was determined that I had weaponized therapy, despite it being court-ordered. And then weeks after the therapist was prevented from testifying, she had to terminate Adam from therapy because he was verbally assaulting her, according to her own notes, verbally assaulting her during therapy. And he was gaslighting and psychologically manipulating in front of her. And so she terminated Adam in therapy because of how bad he was. Now, then the school of Adam's unilateral choosing had become so psychologically harmful to our son that then the therapist who was going to speak about this during that particular hearing now had her arms tied and she could no longer speak about it. So she wrote a letter to the court about this particular school, saying that in no uncertain terms, this school is harmful to our son and that he should not be attending this school. The pastor of that school wrote a scathing letter back to the court and to the therapist saying that if she did not recant her statement, that he would support Adam sourcing a new therapist from the court. And now our reunification therapy, which is court ordered, has become so dysfunctional that the therapist herself has had to discharge our son and me because therapy has become so contraindicated because she is not able to relay information to the court about the custodial harms that are necessitating therapy. And so therapy has become so harmful that we can't even attend our court-ordered therapy. And the guardian ad litem has lied incessantly. And I have all of the proof, and I have gone through, and it's just, and now we're just completely stonewalled.
Good for you.
I affectionately refer to this particular hearing as the marathon hearing. The bias against me was so entrenched by January of 2025 that we had this, he and I had this explosive hearing on, I believe it was January 17th of 2025. I was pro se at the time, and I just reamed him out. And he was trying, he stormed out of the courtroom, and he was saying that he was going to try to find a law that required me to be represented by an attorney because he could not handle me being a pro se litigant. And then what he went ahead and did thereafter, he scheduled more than 24 hearings to occur on one day.
I want to see more people, like young people, become paralegals.
Mm-hmm.
Or like, I don't know, like we need to fund like law school. This would be the real way to fight back, in my opinion.
Well, and I think, I think pushing back slightly, I think that the real way to fight back is to show them that we don't need them. When we talk about the ideas of, because that's the issue, the system generally wants to create this helpless dependency. And so they create the symptoms, they create the problems. It's just Hegelian dialectic. And then we are taught that, again, we need to blindly appeal to authority. And if we're not one of them, then we need their assistance. When in reality, we ought not to. You know what I mean? We need to be far more community-centered.
Yes.
And like you talked about in your own experience, people spend incredible amounts of money and time on these legal bills because, certainly there are good attorneys. Like I'm not knocking all attorneys, but in family courts specifically, they can be so corruptible so easily. And again, when there's already an inherent conflict of interest in the structure of the system, given the merge monopoly that the state has, and then we are taught that we can't possibly read these statutes on our own. We can't possibly write a motion or an affidavit on our own.
Right.
We need someone to handhold everything for us. And because of that, they don't care what the outcome is, because if we don't like the outcome, we'll pay for a de novo. If we don't like that, we'll pay tens of thousands of dollars for an appeal. So we're always looking back to them. So we learn how to operate differently than them, or from them rather, so that we can do it as pro se litigants. But we needed a team of people who have gone through the ringer and they understand the basics of how to navigate the court system. And we don't need to use an attorney. They need to respect us as a pro se litigant.
But I want to see in every candidate's district that their potential voters know who those judges are. Otherwise, they just continue to operate behind this wall of secrecy.
Yeah, and not only that, though, but there's so much retaliation. So when you brought this up before, I wrote this down, because you'll have like attorneys who will try to like unseat a judge because, there's an election coming up and they want to run for a particular judicial seat. And there will be retaliation against those attorneys. So it's like the incumbent, so to speak, doesn't ever get unseated, because a lot of people, unless there's a vacancy, a lot of attorneys don't want to run up against a judge, because if they don't win, there can be in-court retaliation against their clients.
Wow.
So that's a very real problem that a lot of these really good attorneys that should be judges face.
Right.
And again, like one of the immunity things that I forgot to mention before, and so I'm in the 7th Circuit in the Eastern District in Wisconsin for federal stuff. And while I was researching how to write my federal complaint, I discovered there was a local judge that was being sued for, other reasons. And the federal district court, they dismissed the complaint. They threw it out. But the response was, and I'm paraphrasing it, but these few words are verbatim, that judges have, because when you sue federally, you're only suing that for appellate relief. If you sue through the federal district court, you're suing for damages. That's really all that we do. And so this judge said that this federal judge says that judges can't be held liable, so they're not responsible for damages, because judges have absolute immunity. And even when decisions were made in error or were malicious, that was their word verbatim. Even if a judge maliciously makes a bad decision, they have absolute immunity.
So they're just above the law. They might as well just write that.
And they said that the only way that a judge can be responsible for damages is if they practiced, so to speak, in the absence of all authority. So an example would be if you're a traffic court judge and you don't have the statutory authority to go divorce people. And
that's it?
And only then, I mean, there are other instances, but that's the example. So it's virtually impossible. And it's absolutely mind-blowing, which is why my specific case, like so many people have egregious family law cases and law stories. However, what's really unique about my case, and not in a good way, certainly, but in the cases where, like in divorce court, for example, where these are just egregious decisions made by judges, the judge had jurisdiction and authority to make a decision. And so even though it was a bad decision, according to the federal rules,
right,
even though it was a bad decision, you still have the right to make the decision. But in my case, the judge quite literally created a contract out of thin air and imposed a divorce through which it then adjudicated, and then created the exact same harms that you see in divorce court, except in divorce court, there were actual divorces which granted authority to judges to make these types of decisions. In my case, there was no jurisdictional authority allowed. They manufactured their own authority through creating a divorce, and then gave themselves the power to then make custodial and financial decisions on their behalf. People will say to me, I even have this on my website, they'll say, like, was this really worth it? And, how much was at stake? And like, is this, and why do you keep fighting? And, Martin Luther King Jr. even said, injustice anywhere is a threat to justice everywhere. And this is the point. Like, even if I had come out ahead in the divorce and it was conducted illegally, if Adam didn't know, if he didn't recognize that this had been done to him, I would still have fought this. Like, this is why we don't back down to bullies. I don't own the behaviors of other people. And if we had that mentality where I'm somehow responsible for the decisions that other people make because I stand up for my rights, then we're simply promoting a bullying mentality. Our rights matter, whether they're my rights, my son's rights, your rights, or anyone in this country's rights. I fought this. I mean, my entire pursuit for the congressional thing with Glenn regarding my memorandum, that wasn't going to fix anything for me. This was just simply me saying, oh my goodness, I found this train wreck of this jurisdictional gap for domestic relations that's impacting millions of Americans. Please let me fix this for you. Like, that's nothing to do with me. That wasn't going to do me at all.
Right.
And so now, like you, I feel like I have this moral obligation where I've been blessed with this curse. And now I have a moral obligation to stand up for everyone's rights, because people are at risk of this, and they don't even know that. And again, this isn't even just domestic relations. It's all of the other 11 priorities that
Yeah.
if we don't rally together and if we don't recognize the problem for what it is, divided we will fall.
Why do whistleblowers, why do people that stand up and fight against the system, like what's different?
Nothing.
Psychologically?
We're wired differently, and
Yeah.
that's okay, right? And that's
Yeah.
okay. So we can't condemn those who aren't, because
Right.
the bulk of society, they're just not wired like that, and that's okay.
Yeah.
But what
Sure.
we can't have then is we really can't risk the people who aren't wired in that same with that same level of drive and fury. We can't have those people undermine our efforts.
Exactly.
And
Yeah.
that's the risk. We can't have the people
Yeah.
say, well, was this worth it? Well, I'm
Mhm.
sorry. Like, no one would ever say to Rosa Parks, well, if you just went to the back of the bus. Like,
Right.
I mean, no one would say that. And so this is that same thing. Like,
Mhm.
you know, I don't know if you're spiritual or religious or anything, but independent of it, there's this particularly poignant God message. And it
Mhm.
says something to the effect of, I, whomever, asked God, why are you sending me through troubled waters? To which God replies, because your enemies can't swim.
Mm.
And it's so touching, because it's like when we get overwhelmed by these experiences, we just have to remember, again, spiritual or not, it doesn't
Mhm.
matter. Like, we're walking a path. And
Right.
this is happening. What are you
Yeah.
going to do about it? Let's try to make lemonade with the lemons for the world. If you're blessed with intellect, with patience, with articulation, with resilience, if you're blessed with any of these skills, you
Mhm.
better do something for humanity. I feel like this was just a test of my faith, so to speak, and my resilience and my ability to fight for what's right. I'm not coming out ahead in this, but
Right.
I want my son to see, this is what you do in the face
Yeah.
of adversity.
Yes.
This is what you do. You
Yeah.
fight graciously and you fight diplomatically.
And they are watching.
And
Our
they are
kids
watching. I just want him to know that you don't back down to bullies. You
Yeah.
don't. And
Yeah.
this is how you do it. You have
Right.
to be sharp. You have to be
Mhm.
connected. You have to be
Mhm.
patient. You have to be
Yeah.
articulate. And
Yeah.
you have to be able to unite people, because having a divisive personality, that's not helpful. Being
Right.
combative, argumentative, that's not helpful. And so you have to be clever, you know, you have to be tenacious. And we have to have the people who aren't fighters by nature be supportive of those who are. Because
Right.
otherwise we can't do this on our own. And that's really the difficult thing with like the libertarian type mindset and like the independent type people. We generally just kind of want to be left alone, right? So it's like we don't really rally together, to your point. We just don't really have that need to do that, because we're kind of this live and let live mentality. And while that's great ideologically, because we don't try to push our ideas onto other people, the problem with that is when push comes to shove and we actually need community, we really don't have it. Let's not suffer from Stockholm syndrome. We are all victims of the same captors, and the effectiveness of their malevolence is witnessable in our society. Like, you can see it. Like, you can see the divide, and that divide is not indicative of our own ideas. It's representative of our ability to regurgitate their dogma and their mantras. We need to be done with that. We need to come together now more than ever, because we are so close to losing all of it.
There's a whole pool of people that would get involved and probably vote if they felt like they were actually being
do something. Exactly. And I actually have a video out about that already. It's only a few minutes long, but it's my justification as to why independents aren't throwaway votes. Not only are they not throwaway votes, but that is the veto of the establishment.
Yes.
It is for one opportunity to say, we're done with you, in defense of the voters. So here's the thing about independents. They're not throwaway votes. They are valuable, like I said. However, the issue is that in defense of the voters, an independent doesn't really mean anything. It's kind of confusing. You know what I mean? There's no predictability behind what that actually leads to for how someone evaluates a particular situation. Whereas, like it or not, if you're running a leftist platform, you know how you're going to look at the welfare state, you know how you're going to look at borders, you know how you're going to look at all this stuff. Same with on the right. But the issue is with an independent, it's like, well, okay, so what? So you're just going to arbitrarily make decisions on a whim because it's based on what? And that, in defense of the voters, that's also really not helpful. And so that's why my independent campaign, though it's independent, it really is libertarian principled back. And that's for a very specific reason, because though the Libertarian Party hasn't necessarily flourished, their principles, I feel, are absolutely incredible. I mean, they really, truly are. What's challenging about it is there's a very real need for being a responsible adult. You know, there's a lot of responsibility if you value the libertarian lifestyle. And the alternative is that we live in a nanny state. So which way are you going to have it? Are you going to be responsible, or are you going to have your rights and your freedoms taken from you so that you don't have as much control over your life and you don't have as much responsibility? That's why the independent concept, I think, is really great, except it has to be backed by something really strong.
On the top of one of the graphics of the pledge, I said, independent is not a gimmick. Independent in name only, I know. You don't want to be an I know. So I think you're very clear on what you stand for. So you're not an I know.
Something you have to have a North Star, and the Constitution needs to be that. From one judgment, a movement, and the judgment being the divorce judgment, and the movement being the cessation of tyranny, and the movement toward liberty and unity with community. I have a rather unorthodox catalyst for my congressional campaign. This began actually back in January of 2022. My air quote, ex-husband, his name is Adam, so I'll just refer to him as Adam, and the air quotes will make sense later on. But in the beginning of January of 2022, he and I intended to divorce, and I filed an original marital settlement agreement with the clerk of court in Winnebago County, and that would serve as the background for our divorce. And you need a marital settlement agreement in order to have a divorce judgment. And so we had an original marital settlement agreement that I filed with the clerk of court's office. However, shortly thereafter, I learned that that particular document was inequitable and financially advantaged Adam. So I requested that we negotiate terms of an amended marital settlement agreement. And by the end of January, he was amenable to an amendment, and we proceeded to file an amended marital settlement agreement at the end of January of 2022. He and I were both technically pro se at the time, so we appeared before Family Court Commissioner John Birmingham for what was to be our stipulated divorce hearing on February 7th of 2022, believing that we were getting divorced under the terms of the amended marital settlement agreement that was filed at the end of January of 2022. And neither one of us had representation at the time of the divorce hearing, so he and I were in there by ourselves with the court commissioner, and the hearing quite literally wrapped up in a matter of 5 minutes, 7 minutes, and there was nothing alarming about the particular hearing, so we had no reason to suspect anything that was about to transpire. So we left the hearing believing that we were properly divorced under the terms of the amended marital settlement agreement. Well, shortly thereafter, we received our divorce judgment in the mail, and we received a different couple's marital settlement agreement that was attached to our divorce judgment. And we reached out to the clerk of courts, and we said, well, that's a problem. We don't have our marital settlement agreement. Where's our marital settlement agreement? To which the clerk of court mailed us a marital settlement agreement. Well, it turned out that they mailed us the original marital settlement agreement, document A, we'll refer to it as, the one that was filed at the beginning of January of 2022, as opposed to document B, which was the amended version that was filed or submitted at the end of January. And that was still suspicious, so I reached back out to the clerk of court and I said, well, this is still not the correct document, so what's going on here? And they said that they did not have any record of the amended marital settlement agreement, in that they actually lost the amended marital settlement agreement that we submitted to the clerk of court's office, and they did have a record entry that validated that I did in fact submit something to them, and they unfortunately entitled it amended marital settlement agreement. However, that document, along with the several copies that were filed in conjunction with that document, they were lost and then ultimately shredded by the clerk of court's office. So they violated their own record retention policies, and as a result, there was no memorialization of the terms that we believed that we were getting divorced under. And they mistakenly divorced us under the original marital settlement agreement as opposed to the amended one, which we believed that we were getting divorced with. So the woman with whom I spoke, she said, well, why don't you and Adam just try to recreate the lost document and that can solve the problem? Well, I immediately took this to Adam because, again, there were significant financial discrepancies between the two documents. So this mattered, obviously. And so I took that to Adam, and he refused to to recreate the lost marital settlement agreement, and we could not reconcile those differences. And he began interfering with custody and placement of our then young child. And he began to withhold the marital assets because there was no lawful divorce. So then I reached out to Court Commissioner Birmingham, the man who had conducted the original divorce hearing on February 7th of 2022. And I did this at the beginning of April. And I said, we have a problem. I said, and we laid out the terms of what had gone on. Mm-hmm. And I said, this needs to be reconciled. This needs to be fixed. And he correctly so and promptly scheduled a telephone conference for us on April 26th of 2022. And Adam that day had retained counsel. So Adam, his new attorney, Court Commissioner Birmingham, and I attended this particular telephone conference where Court Commissioner Birmingham affirmed the gravity of the case. He said, I've never seen anything like this. I'm so sorry. Yes, in fact, we know that you guys did submit an amended marital settlement agreement to us.
Can I ask you something? Mm-hmm. There are usually recordings in the courtroom, correct? You said it was really quick. Was anything said out, or was this settlement wasn't read out loud or anything like that?
No, and it was not read, and it was so vague that there was significant overlap between both the original and the amended marital settlement agreement, and the only points that were ever discussed by this particular court commissioner were things that were similar between both of the documents. So neither Adam nor I had any reason to suspect that it was the wrong document. So you are correct. There actually was a transcript about that particular hearing, which a later attorney of mine reviewed and said it was the most vague, non-detailed hearing that he had ever seen via transcription. So
were you suspecting anything funny going on at that point?
Not at that point. I thought it was truly just a remarkably strange error. And yes, Adam was beginning to behave in ways that, didn't support the family. However, I thought that this would be quickly corrected by the court, if nothing else, even if Adam's behavior continued to worsen. So I did think that it was going to be resolved relatively quickly. I didn't know that it was going to not be. So then during that April 26th hearing or conference call, the court commissioner, again, he did acknowledge everything that had gone on. He said, I mistakenly divorced you guys under the original marital settlement agreement. And we, the court, somehow shredded the document that you guys intended to divorce under. So he said, I also understand that this document was irreproducible by the two of you, and it's irretrievably lost by the court. So therefore, what he did is he ordered us to, rather than recreate the lost document because it was irreproducible, he then indicated that we were going to be ordered to instead co-create a new document to replace both document A and B, one of which was nullified, one of which was lost. And then as a result of a new marital settlement agreement, he would then have a new divorce hearing. So he scheduled a new default divorce hearing for, I believe it was like May 23rd of 2022. So we had 10 days to co-create a new one, for which then we would have a proper divorce hearing thereafter. On April 26th, we were ordered to co-create a new one as opposed to recreate the old one. So I believe that the new order was actually quite valid. So at that point, as of April 26th, 2022, I actually didn't see a problem with how we were going to be proceeding until that call concluded. At which point Adam quite literally immediately communicated to me that there was going to be significant resistance to co-creating the new MSA, despite us just having been ordered to do so. And so by days later, we made no material progress at all on co-creating a new marital settlement agreement whatsoever. And then I ended up hiring an attorney because I was getting nothing but resistance from both Adam and his attorney. And again, there was significant custodial harm that was beginning to occur and placement interference and things like that. Additionally, I didn't have marital assets to my name. So this is both becoming a financial challenge and a custodial disaster. And then I attended the May 23rd default divorce hearing because I had not heard anything to the contrary that this particular hearing was not going to transpire. I knew that we were not making any progress on co-creating a new MSA. However, I just presumed that we would be able to go before the court commissioner and he would enforce his order to ensure that this get co-created so that we could resolve this problem. However, I got to that particular hearing and I learned from the bailiff that the attorneys collaborated unbeknownst to me and in support of Adam's resistance to co-creating a new MSA to finalize our divorce. The attorneys, along with the court, rescheduled that default divorce.
Your attorney?
Yes, for July, I think it was like July 7th or something of 2020.
Okay, I thought I read that, but okay.
Yep. So the obstruction of the April 26th order and the finalization of the divorce was now prolonged completely unbeknownst to me. So I let that particular attorney go for obvious reasons because there needed to be an expeditious conclusion to this disaster that was unfolding. And I retained new counsel, and now we're in the summer of 2022, and the court commissioner himself retired. So he was the only witness to this particular situation. And then, because the court was experiencing staffing issues during that particular time, the court itself now postponed our default divorce hearing for September 9th of 2022. And during this period, at this point in the summer of 2022, Adam proceeded to withhold our son from me for what became a period of 79 consecutive days and severely alienated him from me, which later on during this process, we had court-ordered reunification therapy, which became a complete disaster, which we may or may not get into. But at one point that was ordered for the purposes of reunifying my son and me as a result of the alienation that occurred from Adam as a result of this court's error. So I coined this term, the court created X exacerbated legal mess. And now essentially incredible custodial harms occurred during this period of time, but now just fast forwarding to the divorce itself. During this September 9th hearing, which was to be our default divorce hearing, no mention of the default divorce hearing ever occurred. And that particular hearing served as a reunification hearing for my son and me, at which point he was court ordered to be reunited with me. Now, in November of 2022, that was our first opportunity to go before Judge Brian Caberline. He was newly appointed to the case, and we went before him. Both Adam and I had representation at the time, and Judge Caberline, in his defense, he mirrored the sentiment of Court Commissioner Birmingham from April 26th of 2022. He said this was an incredible legal quagmire, and he had never seen anything like this before. Again, he acknowledged the gravity of the error, and he also validated the fact that both Adam and I needed to be responsible for co-creating a new marital settlement agreement because the court was not going to force terms onto either Adam or onto me in order to, effectuate this divorce. Well, then shortly thereafter, Adam and his attorney parted ways. We again made no material progress on co-creating a new marital settlement agreement at all. And when we went before the judge in December of 2022, he did a complete 180. And rather than insisting that we co-create a new marital settlement agreement, which was consistent with every single prior order that we had, he decided that actually instead of doing that, we were going to be ordered to recreate the lost marital settlement agreement, despite it being repeatedly part of the record that that particular document was irreproducible by both Adam and me, and that we couldn't reproduce it. As a result, we were told to co-create a new one. So rather than addressing Adam's direct obstruction in this process and ordering or compelling him to, co-create this MSA, he then basically said on January 6th of 2023, you two are going to be tasked with recreating the lost document, despite it being contrary to the record as even a possibility. So the morning of January 6th, this was a hearing in which we were effectively ordered to perjure ourselves under oath. Adam actually had a moment where he called my attorney prior to the hearing, and he expressed to my attorney that he preferred to pursue mediation as opposed to perjuring ourselves under oath before the judge. So my attorney contacted the judge, and the judge flatly refused to allow us to pursue mediation. And he insisted that we attend that hearing that day. So Adam and I went before the judge, and the judge had Adam go first. He swore him in, and he handed him a marital settlement agreement. And he said, certainly I'm paraphrasing, but I've got all of the transcripts to validate what I'm saying. But he handed him a marital settlement agreement, and he said, why don't you write on here what you believe your marital settlement agreement to have been, the one that was lost by the court. Now, mind you, both Adam and I had repeatedly testified under oath to not knowing what that document was anymore, which was why back in April we were ordered to co-create anew as opposed to recreate the loss. So Adam perjured himself, and he just began writing financially advantageous terms to him, and he handed it back to the judge. So then the judge swore me in and asked me to do the same, for which I, again, I'm paraphrasing, but I said, I will not perjure myself. Both Adam and I have already testified under oath to not knowing what the changes were to this lost document. And the judge kind of looked down at me, and he said, we have all day. We're not going anywhere until this is done. To which I said, well, no amount of my sitting here is going to change this outcome for you. So I'm not going to perjure myself. At which point the judge took both Adam's copy and my copy. He went into the back and deliberated for a little bit, and he came back and basically gave Adam everything that he wanted. So the judge, despite never having seen this particular document that was lost by the court, he then, through Adam's perjured testimony, declared that he successfully reproduced the document that was lost by the court, and that as a result, this was going to serve as the basis for our divorce judgment. And ironically, perfectly ironically, he entitled this particular document Marshall Settlement Agreement. And what he did then is he didn't divorce us as of January 6th of 2023. Instead, he stole the judicial approval of the retired court commissioner Birmingham. He applied it to the counterfeit document that he had just created using Adam's perjured testimony, and he backdated it to the February 7th, 2022 divorce hearing that occurred mistakenly before Court Commissioner Birmingham. And then he said, there you go, now we're done. And my attorney had a field day with us, as you can imagine, because he said, I don't know how you can do this. You're asking them to perjure themselves. This is contradicting the record. This is contradicting everything. And the judge just maintained the position that he had successfully reproduced this lost document. So I left that in tears because it was so remarkably unbelievable, and it was such a violation of due process to have us go through this, particularly when Adam, on his own accord, prior to the hearing, specifically requested that we finally can pursue mediation. So then what happened? Days, weeks later, Adam admitted through Our Family Wizard, which was our court-ordered communications platform, Adam finally admitted that the document that was created by him and by Judge Caberline was not actually a facsimile of the document that was lost by the court. So I knew that. He knew that when he said it. However, now I had new information for which I could present to Judge Caberline, and I filed a motion for reconsideration with that as the basis of here's proof from both of these parties that this, in fact, is not a reproduction of the lost document. Therefore, we obviously have an invalid divorce. And by operation of law, which basically means that it timed out, the judge denied the motion for reconsideration. So then I proceeded to appeal this document and the divorce judgment, and this went before the appellate court. They do not have discretionary review, so they actually had to, do a little due diligence. However, they ultimately affirmed Judge Caberline's ruling. Interestingly enough, they affirmed his ruling despite contradicting the justification for the ruling. And They mocked me completely throughout the entire thing. Additionally, so in addition to mocking me, being just completely blatantly unprofessional and contradicting the justification for the divorce from Judge Caberline himself, they then completely misrepresented the facts of the case. So then I filed a motion for reconsideration with them, and that was denied by them within less than 24 hours of my having submitted the document itself. And then thereafter, the next appellate step was the state Supreme Court, and the state Supreme Court has discretionary review. So ultimately, they chose to not proceed with rectifying the situation for me. So now the state appellate apparatus failed remarkably, and I was left with no other option than either accept a flawed outcome and an invalid, illegal divorce judgment based on judicial fraud and forgery, or I could try to pursue relief federally. And so I tried to pursue relief federally because I'm tenacious and I'm not going to back down when constitutional rights are at stake. Mm-hmm. So I began to research what my options were, and you can either pursue relief through the federal district court or you can pursue relief through the U.S. Supreme Court. However, because this particular matter is what they would call a domestic relations matter, which are things pertaining to marriage, divorce, child support, alimony, those types of things. The U.S. Supreme Court generally has this longstanding judicial tradition that they call the domestic relations exception, which more often than not prevents them from being able to hear domestic relations related cases. And the federal district courts have something called the Rooker-Feldman Doctrine, which generally means that the federal district courts are not allowed to act as appellate courts for state court judgments and decisions. So therefore, the only potential appellate opportunity was through SCOTUS, even though I was semi-barred to pursue them appellate-wise because of the domestic relations exception. However, this really isn't a domestic relations matter. This is more of a matter of, again, violations of my civil rights. So I went ahead and I filed a writ of certiorari with the U.S. Supreme Court on May 9th May 9th of 2025 as a pro se litigant. And as I was beginning to research how to craft a certiorari for SCOTUS, I began to learn more about the egregious ways in which we as domestic relations victims are really up a creek and we have no real relief jurisdictionally. So what I mean by that is there is a case called Matt v. Ohio. And that particular case, essentially, it's a U.S. Supreme Court case, and that particular case essentially concludes with state statutes need to be constitutionally aligned. Okay, fine, that's great, right? Then there's a case called Mulker v. New York, and that's about the adherence to the contract law, and Article 1, Section 10 of the Contract Clause. And so what I found as I was doing this research and how I began to craft my writ of certiorari with SCOTUS was, in my case, I have constitutionally aligned state laws, but I have a state court that isn't following the constitutionally aligned state laws. So where is my path to relief when there are constitutionally aligned laws and yet the state itself is the one that's violating it? And that itself is a violation per Mulker v. New York, that itself is a violation of the contract clause of the U.S. Constitution. And I said, there's no enforcement arm to Matt v. Ohio. That particular SCOTUS court only took that issue so far. Making them aligned is not enough. You need to have an enforcement arm for if there are violations of that. And what made my particular path to relief difficult is because it's under the guise of domestic relations. Now, as I was researching the aversion to SCOTUS reviewing domestic relations cases, this dates all the way back to Barber versus Barber, which was in the 1800s. And in essence, they said that they don't generally get involved in these type of matters. And that was reinforced in a case, I believe in the 1950s, but it was called Ankenbrandt versus Richards. And in that particular case, among others, but the SCOTUS court in Ankenbrandt, they said explicitly that, look, we're just kind of going along with this because it's judicial inertia, but it's not really predicated on any particular law that's preventing us from doing this. And so as a result, Congress is the entity that has the power to change this domestic relations exception that we're just kind of going along with because it's judicial tradition. And so as I began to research that more, like I said, I filed my writ of certiorari with the U.S. Supreme Court on May 9th of 2025. On that same day, I had been threatened with jail and fines and loss of custody for my refusal to relinquish our marital property to Adam because of this illegal divorce. And so on May 9th of 2025, the same day that I was in DC filing my certiorari, attorney Kathleen Healy was appointed to act as the receiver of my estate to bypass me entirely and take my properties anyway and go give them to Adam, independent of my authority or involvement. So then on October 6th of 2025, the U.S. Supreme Court came back. They have discretionary review, of course, and so they came back and denied certiorari, and with no, cause. There's no explanation as to why, but they denied mine along with some 800 others that exact day. Now, not coincidentally, that exact day is when Kathleen Healy, the attorney who acted as a receiver of my estate, she then proceeded to sign the receiver deeds to allow that relinquishment of my property to go to Adam. So she waited for the U.S. Supreme Court decision to then effectuate that particular order. And so to this day, now this again occurred, that formally was finalized mid-October of 2025. And to this day, I am now off of the titles of the properties, but I remain the primary borrower on our marital home. And my bank account and my credit is being used for a property that I don't get to legally access and that I don't own at all. And there has been no refinancing. I have received no money for these properties at all. And then, because of the U.S. Supreme Court going ahead and denying certiorari, I filed a petition for review, which I filed, I believe it was maybe mid-November of 2025. And they came back shortly thereafter, I believe it was mid-December, that they then filed they then responded and said that they denied my petition for review. Now, when I was beginning to do all my SCOTUS research, I compiled a list of all these domestic relations risks that not only I faced, but quite literally, tens, if not hundreds of millions of Americans faced with regard to family law, family court, and how this is actually very much a federal matter. This really is not quite as much of a state matter as most people think. And so as I was beginning to do this in August, September, October of 2025, I created a 9-page congressional memorandum, which included the domestic relations exception, the jurisdictional gaps, including Rooker-Feldman and Matt v. Ohio, Mulker versus New York, Title 4D child support, which didn't particularly apply to my case, but it was still a very concerning matter that I then discovered throughout this process. And I explained how when the state is a party to a contract and they are an adjudicator of the contract, you have an inherent conflict of interest, particularly when you introduce federal funding through Title 4D child support. And I said, and I laid out this giant roadmap of all of the things that were wrong with domestic relations and how this is very much federal in nature, and even showcased U.S. Supreme Court decisions that then outright declared that Congress was responsible for fixing these matters. I sent that to all 535 congressmen and women in House and Senate, including Glenn Grothman, the incumbent in my race, and most of whom I didn't hear anything back from, some of whom appeared interested, and I talked to their staffers, but because I was not a constituent, they could not meet with me or speak with me. And Glenn Grothman repeatedly refused to meet with me at all. And so when your congressman refuses to do his job, you don't walk away, you apply for his job. And so that's exactly what I'm doing.